and welcome. Today we have with us Sumit Makhija, Senior Director Deloitte India, to share his views on the UK Bribery Act and the US Foreign Corrupt Practices Act. Welcome, Sumit. Could you tell us a little about both these acts?
So we are talking today about two legislations which are from different geographies but very relevant for Indian industry and Indian corporates. The US Foreign Corrupt Practices Act, also known as FCPA, and the UK Bribery Act. The US Foreign Corrupt Practices Act came into existence in 1977 and it talks about three provisions. The first one being that US listed companies are prohibited from making any bribe or corrupt payments to foreign officials, and it applies to the US listed company operating across the world. So a US company having a subsidiary or a joint venture in India is prohibited, that joint venture and subsidiary included, is prohibited from making any corrupt payments to any public official. The second one being that the books and records of the organization and the subsidiary should be kept in a manner that it provides transparent and complete information. So in very plain and simple words, a bribe should be recorded as bribe in the books of accounts. The third one talks about internal controls. The controls in the organization should be devised in a manner to prohibit or prevent any form of bribery by holding subsidiary included. So that's the FCPA. Now, the FCPA has been in existence for some time now, and there have been many cases involving Indian companies or subsidiaries of US companies operating in India who have been penalized and fined for violating the Act. The second Act, the UK Bribery Act, came into existence in 2011. It's a relatively new act, but far more stringent than any other legislation in the world. The UK Bribery Act talks about four provisions. The first one being that a person is prohibited from making a bribe type of a payment. The second one, a person is prohibited from receiving a bribe or corrupt payment. The third one specifically covers bribe or bribing foreign officials. The fourth one talks about companies, particularly companies having businesses in UK, for having measures to control bribery. So these are the key four provisions, and the reason I say it's far more stringent because it does not differentiate between a public and a private bribery, which means that a bribe paid to another corporate by one corporate is also covered by this legislation. The UK Bribery Act is considered far more stringent than any other legislation in the world, and there are a couple of reasons for that. One, it covers private bribery. So all the other legislations normally cover only public bribery. Public bribery means bribing a government official, while private means a private corporate bribing another corporate. So that's a very different thing from what we have seen in the past. The second one, the coverage of the legislation is far more wide than any other legislation. So just to give you an example, the US FCPA covers US listed companies doing businesses in another part of the world. While this one, in addition to UK companies doing business in another part of the world, also covers other global companies having businesses in UK. So that way, the UK Bribery Act also covers an Indian company having business in UK. So that's a real challenge for global organization.
So, what is the level of awareness about these acts among the Indian companies?
So to the extent we have subsidiaries of multinational organizations or large corporates, Indian corporates who have operations in other jurisdictions including US and UK, they are fairly familiar with these legislations because they have existed, particularly the US FCPA has existed for a period of time. There have been some very stringent penalties on some of the organizations operating in India. So because of that, most of the large organizations have full familiarity, and I think to some extent they are complying also with these legislations. when it comes to the Indian companies, they are much less aware about this legislation and the implications which it can bring to them. So an Indian company having a branch office in UK indulging into any form of bribery in any part of the world is covered by UK Bribery Act. So that's the strength or that's the stringentness of the UK Bribery Act which I was talking about in your previous question.
And what could be the legal repercussions of non-compliance?
In case of US FCPA, which has been there for a fairly long duration, one has seen large number of companies being penalized, and the penalties have been determined based on the amount of profits or amount of sales the companies have driven or got because of the corrupt or bribe type of payments. There have been also implications in form of World Banks or the governments actually stopping doing business with those organizations. UK Bribery Act is a relatively new legislation being enacted in 2011. So there's a lot to be seen, how the prosecution is going to be. But I think it's going to be in the similar manner as the US FCPA has been.
Could you suggest some preemptive measures for companies to adopt?
So the preemptive measures which the companies, we usually advise companies to take are a lot similar to what the UK Bribery Act guidance also says. So we usually tell companies that they should have mechanisms in place which are one, proportionate to the size and the nature of the business. So just to give an example, a company in a riskier environment from a bribe or corruption perspective should have more stringent measures as compared to a smaller company in a probably low risk environment. The companies actually should carry out risk assessments on a regular basis, which includes the risk of corruption and bribery. They should have the top level commitment. It's very essential that the board or the chairman and the senior management should have a commitment to prohibit bribery at the company. There should be communication. The company and the senior management should be regularly communicating about their efforts and the need of having a clean environment in the organization. Particularly to the extent they're working with third parties or agents or their service providers, they should be doing enhanced due diligence to the extent they are representing the company to find out if they are indulging in any corrupt practice on behalf of the company. So that's also essential. And the sixth and the last one is that they should be on a regular basis monitoring and reviewing the operations of the company. And these 6 measures are actually good from any compliance or any control perspective also.
Sumit, there's a huge interest in the varied fields of forensic these days. Please guide our viewers in certain professional qualifications required to pursue a career in this particular field of forensics.
So forensic has many different facets or streams. The professionals which we have currently are in our team range from typical accountants, MBAs, some former regulators, some former law enforcement officers, analysts, and some field investigators. So what one needs in this field, and which is the single most important bit, is to think like what a fraudster would think, because ultimately you are investigating a case, and to investigate a case you need to think what the fraudster or the perpetrator of that particular fraud would have done. But from an educational qualification, we look at chartered accountants, we look at people having accounting degree, knowledge of finance, to some extent, the knowledge of computers is of course essential today, but we have a substream called data analytics and computer forensics. There we need engineers, and a lot of this has to do with the inquisitive mind which can solve puzzles, a puzzle of fraud.
Thank you, Sumit. So this was Sumit Makhija, Senior Director, Deloitte India, sharing his insights on 2 of the key legislations of great importance for the Indian corporates. Subscribe to the Deloitte India YouTube page for more such insightful videos. Keep watching.